Hohenscheid case and the assignment of business income resulting from a sale. That's the subject of today's ACTEC Trust and Estate Talk.
Welcome to ACTEC Trust and Estate Talk from the American College of Trust and Estate Counsel, a professional society of peer-elected trust and estate lawyers in the United States and around the globe. This series offers professionals best practice advice, insights, and commentary on subjects that affect our profession and clients. And now, our ACTEC Fellow host with today's topic.
This is Travis Hayes, ACTEC Fellow from Naples, Florida. As estate planning and tax advisors, we are often contacted by business owners preparing their companies for sale. Recently, the tax court issued a ruling in the estate of Scott M. Hohenscheid versus Commissioner case regarding the sale of a business. Many practitioners are now left wondering how the decision in Hohenscheid could impact other assignments of business income. ACTEC Fellow Gray Edmondson of Oxford, Mississippi, is joining us today to discuss the Hohenscheid case and share his takeaways from the ruling. Welcome, Gray.
Thank you, Travis. And it's certainly true that the Hohenscheid case has shaken a lot of people's belief in the way assignment of income is treated in gifts of equity interest before primarily a liquidity event, right? A sale of a business or a sale of a piece of real property. And traditionally, most of us have believed that the law required there to be some level of a binding commitment to sale before we would be in a problem from an assignment of income perspective. And so stepping back from that briefly to just what is an assignment of income is sort of a fundamental matter. And the notion is that going back to the 1960s case called Humasid, the rule is that a taxpayer is allowed to make a gift of an asset before it is sold ultimately to a third party, to a charitable organization, and get two benefits effectively: a deduction for the value of the asset gifted, subject to certain exceptions that could limit that deduction to cost basis, as well as avoidance of capital gains on that particular asset. And so it's real common to engage in a strategy whereby a gift of an interest in a business or a piece of real property or another asset that's being sold to a charity before that sale to take advantage of those double benefits, to get a fair market value deduction, and then also to avoid capital gains on that income. And so where the test for assignment of income and where the rules that were sort of initially laid down in that Humasid case come out of is, how do you know whether you get the double benefit of a fair market value deduction as well as avoiding the gain? And so what the Humasid case says we look at is, we can avoid the gain if the gift of the appreciated property is given away absolutely with a full divestment of title to that asset, and it's done before the property gives rise to income by way of sale. And so the real question on the second part of that Humasid test is, when in the spectrum of a sale transaction have we gone too far so that we now, as the taxpayer who intends to get the benefit of avoiding that gain, have already received the right to that taxable income? And once we cross that threshold, that becomes taxable to us, notwithstanding the charitable gift. And so going back to a few different authorities that are out there, a Palmer case, an IRS revenue ruling 78-197, and then a Rauenhorst case, all were in a string of authorities that indicated that when there's not a binding, legally enforceable obligation to sell that asset, as long as we make the transfer before it becomes binding and before there's a written binding obligation to sell, we're fine. That was essentially deemed or thought to be by many planners to be a bright line rule. So as long as we were before one end of that bright line and not after it, we were good. The Hohenscheid case sort of shook that up and said, we're not going to look at a bright line test. We're going to look at this from a facts and circumstances basis. A point of disagreement I think some of us in the planning world have. I can speak specifically. Steve Gorn, another ACTEC fellow, and I have spoken about this case extensively, have given a couple of presentations about it. He sees the Hohenscheid case as a major change in the law. I think it's the first time this outcome has been reached by the tax court. But in that prior Rauenhorst opinion I mentioned, I feel like the tax court left its foot in the door by saying in some of its language in that case that we don't think this is the case to upset the bright line rule that's been out there, but we do think on the right facts that we will look beyond this bright line test. And so, is that a change in the law? Was it really the law from Rowlandhurst forward, and this is just the first time the court's viewed it this way? You be the judge of that. But at any rate, what the court said is we're going to look and see, had we gotten too far gone? And the court looked at 4 factors. Was there a legal obligation to sell? They admitted in Hohenscheid there wasn't yet, but they also looked at 3 other factors. What actions had been taken by the parties to effectuate the transaction? What remaining transactional contingencies existed? And what were the status of the formalities required to complete the transaction? When we look at those factors, the steps already taken, the buyers and the sellers here had received all of the regulatory authority they had to obtain to engage in the transaction, all of the corporate requirements they had to fulfill to engage in the transaction, had notified third parties of the transaction. And so the actions that had been taken were pretty far along. In addition to that, the corporation that was going to be sold had distributed all of its cash before the sale occurred, or substantially all of its cash, such that it could not have continued to do business without more cash being infused that was anticipated as a result of the sale. The next one, unresolved transactional contingencies. The facts cited by the case show that at the time this gift was made, there was only one red line remaining in the purchase agreement that was being negotiated to be signed. It was a transaction where the contract was going to be signed contemporaneous with the closing instead of having a contract with a period between the contract date and the closing date. It was all going to be contemporaneous. But at the time the gift was made, there was only one item being negotiated, and it was a non-substantive item dealing with some language around how one employee was going to be treated, really at that employee's request, I believe. So that really wasn't anything that was going to hold up the deal. And the status of formalities, as I mentioned, everything had been approved at the corporate level on both sides. Acquisition subsidiaries formed, regulatory approvals made, distributions made to fund dividends to the shareholders, and in addition to dividends to the shareholders, payment of a change of control bonus to employees. And so when the tax court looked at this and saw we had gotten so far along in the transaction, the language the court used there was that it was a foregone conclusion that this was going to sell, and that there were only ministerial acts remaining. And when that's the case, the court said, we're going to render this to be an assignment of income. So where does that leave us, right? And I think where it leaves us as planners is we have to ask the question when we're advising clients about making gifts of assets before a sale transaction, not are you legally obligated yet to sell this asset, but we have to go through these facts and circumstances tests to say, are there any contingencies that remain outstanding? Are there formalities that remain outstanding that would have to be completed? Have you done other things that would make this transaction too far gone to turn away from? And if so, notwithstanding the lack of there being a binding obligation, maybe you're too far along. And I think that's really the nutshell of Hohenscheid. And really aside from the assignment of income case, I'll just put a sort of another note out there. This taxpayer not only lost their ability to avoid the gain on those shares that were gifted to charity before the transaction, he also lost, Mr. Hohenscheid lost the ability to take a deduction whatsoever because he obtained a valuation from someone who was not a qualified appraiser. And so he also messed up the charitable gift substantiation requirements. And so it was sort of a total whipsaw for the taxpayer. And really on the assignment of income, maybe not his doing. His lawyers were giving him advice that if you haven't gotten a legally obligation, or if you don't have a legal obligation to sell, you're not too late probably. But they certainly never told him to get a free, unqualified appraiser to value his stock, which is what he did. And so he kind of lost across the board. And so I think it's a lesson both to planners and taxpayers about the facts and the circumstances you have to look at in determining whether an assignment of income would be a problem beyond just a legal obligation to sell, and then also a lesson about don't cut corners on charitable gift substantiation.
Thank you, Gray, for discussing the Hohenscheid case and what practitioners should take away from the tax court's ruling.
Thank you for listening to this episode of ACTEC Trust and Estate Talk, the podcast series about wealth planning matters from the American College of Trust and Estate Counsel. To find an ACTEC lawyer near you, visit actec.org. Please subscribe to this series and leave us a rating or a review.